Welcome back, folks. Let's move on into courts, prosecution, and the defense. So, we'll start with state courts. State courts are free to develop their own court systems. State courts handle a wide variety of cases, but they have a limited jurisdiction. They handle misdemeanor criminal infractions, violations of municipal orders, traffic violations, civil suits where damages are less than $1,000. There's about 13,500 independent courts of limited jurisdiction. Criminal matters that they tend to hear are misdemeanors such as shoplifting, disorderly conduct, and things like simple assault. And their sanctioning power is somewhat limited. In criminal matters, punishment may be limited to fines, community sentencing, or incarceration in county jails up to a year. We also see specialized courts. Specialized courts are increasingly where state courts partition several types of courts to hear only certain types of cases. Things like drug courts, mental health courts, community courts, domestic violence courts are all specialized courts. Drug courts, as many of you know, are an alternative to drug sentencing. Courts of general jurisdiction is another type of court. There's approximately 2,000 of these nationwide. State or federal courts have jurisdiction over more serious felony offenses and civil cases where damages are over that $1,000 and may be called to work on felonies, superior Supreme Courts, or circuit courts to adjudicate justice. And they're organized into judicial courts. Appellate courts, these do not try cases but review procedures of cases. And the ultimate appellate court is the Supreme Court, state Supreme Court, and that is considered the court of last resort. So appellate courts reconsider a case that has already been tried in order to determine whether the measures used complied with accepted rules or criminal procedures and were in accordance with constitutional doctrines. Each state has at least one court of last resort, and as I mentioned, it's usually called the Supreme Court. And a few states have two appellate court systems, one for civil matters and one for criminal matters. This flowchart gives an idea of how the court system is structured. The state Supreme Court sits at the top, moving down into the intermediate appellate courts, the Superior Court, the lower court, and the Justice of the Peace. Federal courts. The legal basis for an independent federal court system is contained in Article 3, Section 1 of the U.S. Constitution. It creates U.S. district courts, and there are 94 independent courts in operation. They have jurisdiction over violations of federal laws. When we talk about appeals courts, we're talking about the U.S. Court of Appeals. There are 13 judicial circuits, each with a court of appeals, and they're empowered to review federal and state appellate court cases on substantive and procedural issues. As we mentioned, the district courts, they're trial courts of the federal system, and they were organized in 1789. and the U.S. Court of Appeals, consisting of 13 judicial circuits, each of its own courts of appeals. These courts may review the decisions of the U.S. District Court as well as decisions from the state courts. They're empowered to review state and federal appellate court cases on substantive and procedural issues involving rights guaranteed by the Constitution. And they analyze judicial interpretations of the law and reflect on constitutional issues involved in each case they hear. But what they don't do is retry cases. The U.S. Supreme Court, or the nation's court of last resort, as you can imagine, this is an appellate court. The U.S. Supreme Court grants a writ of certiorari to hear cases. When the court rules on a case, it becomes a precedent or a landmark decision. And the Supreme Court has a procedure that it follows. It reviews written arguments, it hears oral arguments, and it reevaluates and reinterprets state statutes, the U.S. Constitution, and previous case decisions. Here's a flowchart of what the federal courts look like. It starts with the Supreme Court, the United States Supreme Court. Then we move to the appellate courts, the U.S. Courts of Appeals, where we have 12 regional circuit courts of appeals and 1 U.S. Court of Appeals for the Federal Circuit. We have trial courts. As I mentioned earlier, there's 94 judicial districts. This includes the U.S. Court of International Trade and the U.S. Court of Federal Claims. And then, of course, there are the federal courts and other entities outside of the judicial branch. This includes military courts, Court of Veterans Appeals, U.S. Tax Court, and federal administrative agencies and boards. To move into the judiciary. In the judiciary, the judge is the senior officer in the court. They oversee the trial process. They instruct juries. They decide whether defendant's guilt is determined in bench trials. They control and influence court agencies like probation clerks, police, and the district attorney's office. When we think about the judiciary, what we're really thinking about is the judge and the justice system. Judges' attitudes and philosophies have a major impact on the justice system. They also affect police policies and district attorneys' offices. Qualifications and selection of judges and for the judiciary. Federal judge is appointed by the president with advice and consent of the Senate. The process can be controversial and political depending on the judges. We saw this recently with the Judge Kavanaugh appointment to the Supreme Court. One exception to this process exists for the appointment of a U.S. magistrate judge. Magistrate judges are federal trial judges appointed by district judges who preside over various civil cases with the consent of the parties and over certain misdemeanor cases. There are no formal qualifications, but generally only the most qualified lawyers are appointed. Now, this might not be the case, especially over the past 4 years. It seems like the standards have been lowered on who becomes federal judges. The judiciary at the state level. Of course, qualifications vary from court to court. In some jurisdictions, judges are appointed officials. Another form of selection is popular election. It's referred to as the Missouri Plan, where a commission selects and nominates potential candidates. An elected official makes appointments from the committee, and a nonpartisan and non-competitive election takes place. But, all in all, quality of the judiciary is still a concern, because when you don't have any formal qualifications, then some people that are unqualified can get appointed for political purposes. Prosecutor represents the public in criminal matters. Jurisdiction spans the entire justice system process. They determine whether criminal charges should be filed. They represent the state in pretrial activities, hearings, criminal trials, and appeals. And they act as legal advisors to county commissioners and other elected officials. Types of prosecutors. Well, we have federal prosecutors. They are known as U.S. attorneys and are appointed by the president. They represent the government in federal district courts. The chief prosecutor is usually an administrator, and assistants normally handle the actual preparation of the case. We go to the state level. This is the attorney general, and the county level is the district attorney. Here, most criminal prosecution and staff work is done by full and part-time attorneys, police investigators, and clerical personnel. Most attorneys who work for prosecutors at the state level are political appointees who earn low salaries. In urban jurisdictions, the structure of the DA office is often specialized. But in rural areas, the chief prosecutors handle many of the criminal cases themselves. The practices, organizational structure, and political atmosphere often restrict the effectiveness in investigating and prosecuting criminals. Lately, the prosecutor's public image has improved. They've begun more aggressive investigations into white-collar crime, drug peddling, and corruption. There are about 2,400 state prosecutors' offices in operation. They employ about 79,000 attorneys, and usually the most active prosecutors are in large counties with populations more than 500,000. Now, confronting issues of cybercrime and terrorism is becoming a more common task for prosecutors. At least 2/3 of prosecutors have litigated a computer-related crime such as credit card fraud, identity theft, or transmission of child pornography. About 1/4 participated in state or local task force for Homeland Security, and most prosecutors relied on state-operated forensics laboratories to perform DNA analysis. Continuing with the prosecutor, prosecutors decide which cases are prosecuted. They use discretion in making this decision, although some analysis is usually done to determine the probability of a conviction based on the strength of evidence. Even with felony cases, prosecutors ordinarily exercise much discretion in whether to bring a charge. Prosecutorial decision-making can only be controlled or overturned if a defendant can prove the prosecutor-led discrimination guide their decision-making. Barbara Boland did a study where she looked at the flow of felony cases in 3 jurisdictions: Golden, Colorado, Manhattan, and Salt Lake City, Utah. Prosecutors used their discretion to dismiss a high percentage of the cases before trial. When cases were forwarded, few defendants were acquitted, and a high percentage of cases ended with the defendant pleading guilty. The prosecutor, in the end, played a limited role in exercising discretion in minor offenses, and they may consult with police and leave decision to discretion of law enforcement agencies themselves. Excuse me.